So we need to talk about a recent 9-0 unanimous decision issued by the Supreme Court involving the Fourth Amendment's protections against when excessive force by law enforcement actually impacts your rights. And right now, the Fifth Circuit just issued a new ruling in light of what the Supreme Court said. So let's talk about what is happening. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is to simply subscribe to the channel. Also, double check to make sure YouTube has not unsubscribed you. They especially love to do that on two-way channels. And it'd be really cool to try to reach 900,000 subscribers before the end of the year, so I'd love your support. As I mentioned in the intro, in this video, we're going to be discussing a recent 9-0 unanimous ruling issued by the Supreme Court. This case involves the Fourth Amendment's protections against unreasonable searches and seizures, and when law enforcement activities through excessive force actually impact those rights. This unanimous ruling came in a case called Barnes versus Felix, and it's a case we've been covering here on this channel. Now, this new lawsuit should be on everyone's minds because it involves how courts must now analyze these types of situations in all of these types of cases going forward. As gun owners, we have seen a lot of highly publicized situations where law enforcement interact with lawful gun owners, and through excessive force or mistakes, the gun owner ends up being shot or something fatally happens. This analysis by the Supreme Court directly impacts those types of situations. And now the Fifth Circuit has issued a new ruling in light of what the Supreme Court said in that 9-0 unanimous ruling. And the Fifth Circuit once again ruled that the police officer here and his actions are protected under the totality of the circumstances approach, that he has qualified immunity. But this is now heading to the Fifth Circuit en banc panel for re-review. And this is all happening just months after the Supreme Court said for the Fifth Circuit to re-review this case, but then they did some procedural kind of shenanigans and didn't fully review this case in light of what the Supreme Court said. Now, the facts surrounding this case are as follows. Essentially, Roberto Felix Jr., a law enforcement officer, pulled over an individual, Ashton Barnes, for suspected toll violations. I believe the toll violations were picked up by some Houston freeway cameras. There were some toll violations, so the officer pulled him over. Now, Felix ordered Barnes to exit the vehicle, but Barnes essentially opened his door, acted like he was going to exit the car, but then attempted to drive away. Reacting in a split second, the officer jumped onto the ledge of the car as it was driving away. He then fired 2 shots at Ashton Barnes as the car was driving away, and eventually he was fatally hit as well because of those 2 shots. He passed away, but then the car actually did stop. Now, about 5 seconds elapsed in total between when he had contact with Ashton Barnes, when Barnes opened the door, when the car started to drive away, when the officer jumped onto the ledge of the vehicle. That was a totality of 5 seconds. Barnes's mother sued the officer on behalf of her son, alleging that the officer violated his Fourth Amendment rights against excessive force. However, the district court on review granted a summary judgment in favor of the officer, and they applied what was known as the Fifth Circuit's moment of threat rule. This case was then appealed to the Fifth Circuit, and the Court of Appeals on review affirmed, explaining that the moment of threat rule requires asking only whether an officer was in danger at the moment of the threat that essentially resulted in his use of deadly force. Under that rule, events leading up to the shooting are not relevant or considered at all. Now, this case eventually made its way to the United States Supreme Court. In last term on review, the Supreme Court issued a unanimous ruling in favor of Ashton Barnes, and they held that a claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. They stated that the inquiry into reasonableness of the officer and the force used requires analyzing the totality of the circumstances. That analysis demands careful attention to the facts and circumstances relating to the incident. So in this case, the Supreme Court rejected the more limited moment of threat analysis that was used by the Fifth Circuit, and instead they applied something known as the totality of the circumstances approach. Now, after the Supreme Court issued that ruling, the case was then sent back down to the Fifth Circuit for re-review in light of what they just said in that 9-0 decision. And they were ordered to apply the correct totality of the circumstances approach. And because, the moment of threat rule was rejected, they had to apply the totality of the circumstances. Now, interestingly, something has developed in this case. The Fifth Circuit 3-judge panel on their own decided to not hold oral arguments in this case, decided to not request additional briefs in this case. Instead, when it was remanded back down to them because of that new Supreme Court ruling, they decided to re-rule on the case on their own and did not request any of the additional briefs or any new oral arguments in light of what the Supreme Court just said. And in the new ruling, the panel held that even under the totality of the circumstances approach, the officer's actions were warranted. The panel reasoned that any vehicle flight creates a deadly threat and that the officer here reasonably used lethal force to prevent that type of dangerous situation. Because of that quick new decision without additional arguments or additional briefs, Ashton Barnes' attorneys are now petitioning for the Fifth Circuit en banc panel to take this case, re-review the case, or at least reverse what the Fifth Circuit just said and remand this back down to the lower court for further developments of the record. The petition argues that this new ruling contradicts what the Supreme Court just said in their new decision, and even Judge Higginbottom's, own earlier concurrence in this case, where he stated that deadly force would be unconstitutional under the totality of the circumstances analysis. So he already said in a prior concurrence that if the totality of circumstances was applied in this case, he would have to rule in favor of Ashton Barnes, but when they re-reviewed this case, suddenly he ruled in favor of the officer. The petition urges for a rehearing because the new ruling effectively creates this per se rule that officers may actually be able to shoot any fleeing driver even when only a minor stop or prior situation which was minor was actually involved. It argues that this conflicts with what the Supreme Court just said in this case prior and other cases, and with long-standing Fifth Circuit precedent that fleeing in a vehicle does not automatically justify deadly force. The petition also highlights a deep circuit split, noting that most other circuit courts require case-specific threat analysis rather than just treating any flight of a vehicle as something deadly where this type of force is justified. The petition points out that the stakes in this case are very high and that this is an extraordinary case, and they also warned the Fifth Circuit en banc panel that this type of per se rule created by the lower court would actually encourage police officers to potentially engage in more of these types of situations, potentially more shooting because, traffic stops are a big part of, an officer's duties, and to have this per se rule where any fleeing vehicle warrants deadly force is just something that you don't really want on the books. In this petition, they asked for either the Fifth Circuit en banc panel to send this case back down to the district court for a new ruling with a further, development of the record, or they asked for the en banc panel here to take the case and issue their own ruling. So this is something that we're going to have to watch closely to see how this plays out. Again, it's surprising that the Fifth Circuit three-judge panel decided to issue a new ruling on their own in this case without requesting additional briefs, supplemental briefs in light of what the Supreme Court just said in this very case, where they struck this case, prior ruling down in a 9-0 decision, sent it back down to the Fifth Circuit. But even with that, I guess the Fifth Circuit did not see any reason to request additional oral arguments or briefs in light of that, and instead they issued their own ruling. Ultimately, I think that procedural misstep will push the en banc panel to get involved in this case, or at least reverse that ruling and send it back down to the district court for a new hearing and further development of these records and facts based on this situation. So that's what's currently happening in this critical case, which is coming off of a recent 9-0 unanimous ruling by the Supreme Court. And now we're going to have to wait to see, how does the Fifth Circuit en banc panel deal with this case because of that new ruling by the lower court. So as we get more information, I will let you guys know. So if you guys like this video and you would like to support the channel, one of the best ways to do that is to simply like, comment, and subscribe. All those things help the channel to grow. Also, you can check out one of these two videos here on the screen that the YouTube algorithm thinks that you will find educational and helpful. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.